What if I told you that debt discharge isn't about running from a responsibility? It's more about fulfilling the obligation in a way that they don't teach you. Now, in this video, I'm going to break down the real meaning of debt discharge, how it differs from forgiveness or default, and why understanding commercial law flips the power back to you without breaking any laws. Now, before we dive into this, I've studied credit systems, the UCC, and lawful contracts, and I'm here to show you that debt discharge is a performance. You dig me? And it's just not the kind that they want you to know. It's just not the kind that doesn't make them more money, okay? So before we dive into this is not legal advice. This is not financial advice. Do your due diligence. Make sure you are using your head, okay? Don't just watch these videos and just employ these tactics without using your brain, without using your own due judgment. You know what I mean? So another thing, if you're brand new, make sure to like, subscribe, turn on the post notifications because I do post daily content Monday through Friday. All right, let's dive straight into this, okay? Most people think discharge equals escape, okay? And when people start to think like this is the reason why they think things are not believable or not true, okay? Once you understand exactly what debt discharge means or discharge means, then you can stop moving from a place of fear, a place of, oh, I can't do this, okay? So let's just look this up real quick. Discharge, okay? In legal context, broadly refers to the release from a legal obligation, duty, or restraint. This can include being freed from a debt, a contract, a jail sentence, or even a military service. All right, now that we got that covered, people assume discharge means running from a debt. People assume discharge means avoiding payment. And people assume that discharge means that you're breaking a contract. But the reality is, in law, discharge doesn't cancel duty. It completes it through different means. Now, remember, when I talk about discharge, it's a performance, okay? Typically, your only performance that you think you can do is pay with the Federal Reserve note. But what if I told you that discharging was an actual lawful fulfillment? You know what I mean? So it's not about paying, but it's about how you perform, okay? A contract requires a performance, okay? So even when you look at the definition of tender, and they'll say, well, you need to give me legal tender, okay? When you dive into tender, it says to unconditionally offer money or performance to meet an obligation. So it can be a performance. Nowhere does it say that a tender is the dollar bill. You got me. So let's dive into the next thing, okay? Let's talk about the aspect of discharge versus forgiveness. So I got this quick diagram, okay? So real quick, let's just talk about the difference between discharge and the difference between forgiveness and the difference between default, okay? Number one, when you look at discharge is a lawful fulfillment, okay? Discharge is backed by codes and law, and discharge can be initiated, all right? You can actually initiate a discharge. You know what I mean? So let's talk about the difference between discharge and forgiveness. Forgiveness is canceled by a creditor and often taxable. And it also requires approval. Okay, you need to ask for permission. You dig me? So it's not in the aspect of you can initiate it. It's not something that is typically backed by codes or law. And it's not a lawful fulfillment. It's more of the creditor says, hey, you have permission to cancel this. Okay? And then let's talk about default. Default is a breach of an obligation, meaning you didn't perform. Number two, it leads to collections. And number three, it can damage your credit. So you usually don't want a default on your credit. You want to either get it discharged, okay? Discharging is your right. It's not a favor like forgiveness, okay? And the creditor still gets paid just not by you directly. So when you look at the definition of discharge is a transfer of an obligation to a different party, and that party will fulfill your payment or your performance, okay? A lot of you guys don't understand that your you have the right to do this because you are under a system you're under a credit system that literally is not even real money. So if you report the certificate of indebtedness, or you report that there is a debt that you owe, it's already insured by the government. Okay. Now, how discharge actually happens. Discharge actually happens via remittance. Either you're going to use a coupon return or a payment voucher. Okay, you get the bill statement. You send the bill back to the company. On the bottom part, it's a check. People look at that and think that that's the bill, but it's actually a check. It looks just like a check. It's actually a coupon attached to a bond. And then when you send that coupon attached to a bond or accept it for value and you remit the bill using that coupon, that is a version of discharge. The other aspect is via insurance payouts, bondings, or third-party coverage. So in the other instances where like I said before, your debt is insured, FDIC insured. Most credit card companies and most banks are FDIC insured. People look at that and think, well, this just means that they're official. No, it means that it's insured. It means that if you don't pay it, they're going to get paid out regardless. Okay. The other aspect is UCC, tender of payment. People look at discharge and don't understand that there's a law under tender of payment where you can create your own tender, your own unconditional offer, your own unconditional performance to meet an obligation. Okay. Then we dive into offering a negotiable instrument or a bond. A negotiable instrument can be is essentially a promise to pay. Okay, it's an unconditional promise to pay with your signature. Okay, of a fixed amount. Okay, as long as you unconditionally promise to pay something, that becomes a negotiable instrument that they can use as a financial asset. Okay, and then sometimes through settlements, agreements, or administrative process. So if you get in a situation where you are being challenged on the debt and you challenge the company on the validity of the debt and they let's just say are unable to prove the debt, or let's just say that you are going through a negotiation with a company and you get to a point where you settle on the debt, or you settle for pennies on a dollar, or you find out that they never funded the loan and you prove this to them, or they cannot prove that they didn't that they funded the loan, things in that nature, or there was a lack of disclosure and you start to challenge them on these things, and now they're in a position where they cannot reply back, or they're violating your rights. Now they get in a position where they're like, damn, well, I don't want to get sued for this stuff, so let's just go ahead and settle it. Okay, either I'm gonna settle it or I'm gonna just let you go about your merry way. And when I let you go about your merry way, I'm actually refusing or forfeiting my ability to collect from you. Okay, so if you take a company through administrative process, or you try to settle, or you try to negotiate with them and the negotiations don't work in terms of they don't either accept your tender of payment, or they're unable to provide the proof that they can legally collect on a debt, now they're in a situation where they either have to settle or go to court. Okay, and fight it in court. And if you're a person who do this properly through the administrative process, this is something I'll talk about in the Complete Debt Guide. If you're a person who does this properly through the administrative process and you build your evidence substantial enough to be able to bring it to court, and you can communicate your evidence in a proper way so that they can look stupid for not doing their duty and performing on your contract, which we'll talk about some of the laws that this is backed by, then they are in a position where they are violating the rights. They are in dishonor. And when they dishonor you, that is a violation. That's something that you can sue them for. That's actually a criminal violation. Okay? That's fraud. Okay? That's, we'll just stop at fraud. Okay, so if the creditor receives value even from another source, the obligation is discharged. So a lot of people think that, okay, well, my debt is charged off. If my debt is charged off, why are you still coming after me for the debt? Well, they don't really give you no real reason. Okay, it's not that you need to ask them for permission. Is you literally say, hey, the debt is settled, so there's nothing for you to come after me for. You already made your money. Are you trying to get double recovery, which is actually illegal? Okay, it's illegal for you to try to double collect. It's illegal for you to try to double recover after something has already been settled. Okay, so Banks would do this to you. It's called double dipping. And you can actually bring this up in the face of the evidence. You can bring this evidence up in court. You can bring this evidence up to them. Okay? You bring this evidence up to them, they have no choice but to follow directions. Okay? So now let's talk about the laws that back it up. Getting straight to the point, man. This is one of those videos that I want to get straight to the point. Because a lot of times we look at discharge and a lot of people think that you're doing something wrong or you're doing something unlawful. I just did a video talking about, are you going to go to jail for discharge? No, you cannot go to jail for discharge if you do it properly. But there's a lot of times we try to just do things off of what we see on the internet. We just try to just send in one little letter. You know, we don't even know what the letter is saying. We don't even understand what it is saying or how to even communicate it properly. And then they'll send you a letter back saying, well, this is fraudulent. Well, you don't know that you need to respond back to them and tell them it's not fraudulent and tell them to prove that it was fraudulent. If you're unable to do that, and if you don't do that, then yes, you're going to be in a position where you are committing fraud because they said you did and you didn't assert your rights and say you didn't. You know what I mean? So when you don't do that, then you actually assent or agree to whatever they say. Stop just unknowingly agreeing to whatever they say. This is why in my previous video, I talk about how your awareness is what really brings your sovereignty. It's not paperwork. Because I know many people who do paperwork but still don't understand that they are sovereign. They're still yelling at creditors about their sovereignty, but it's not about you yelling to them. It's about you being aware of that is and just exercising it properly. If you don't exercise it properly, then yes, you're going to be put in a position where they take away your sovereignty. Okay? And it has nothing to do with you doing paperwork, because you can do paperwork and it still wouldn't matter. Okay? So don't just pay somebody to do your paperwork and you don't even know how to do it. You don't even know how to negotiate your debts. You don't know the administrative process of sending letters through your trust. You don't know how to do these things. And if you don't know how to do these things, then what is the point of you going through all the rigmarole, creating a trust that you don't even know how to use? Okay? So I typically say that ignorance on fire is better than knowledge on ice. But when it comes to an aspect of this, you want to actually have full knowledge of it to the point where you are comfortable with the information. It's not that you need to know every single thing, but you need to be comfortable with the info before you start to exercise these things. Because your comfortability and your information, your education behind it is actually what's going to fuel you to take action. Okay? Don't do this and you're uncomfortable and you don't believe in it. If you don't believe in it, then I would tell you to click off the video right now. Don't go in the comment section and say, well, look, how come this, that, and the third? Okay? But since we are in the middle part of the video, go ahead and like the video. Go ahead and subscribe. Go ahead and tap in to my Instagram down below. The link is in the description. Whatever the case may be, man, this is just the middle of the video, and I want to make sure to tap in with you guys. All right, thank you guys. We hit 20,000 subscribers, road to 100,000 subscribers. So go ahead and hit that subscribe button and turn on the post notifications. All right, let's dive into these laws. Okay, now, first thing we're going to talk about is the tender of payment, which essentially discharges an obligation. Going straight down, UCC 3-603, it says, if a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of the tender of the obligation of the endorser or the accommodation party having the right of recourse with respect to the obligation on which the tender relates. See, I can talk about this in every single video and somebody will still get on the phone with me and say, well, I sent them the tender and they refused it. Okay, well, what does that mean? Oh, I've been watching all of your videos, so you should know exactly what that means. If they refuse it, then the ball is in your court. Now you have to challenge them and say, well, you guys refused it, and you shouldn't be expecting another bill. If they send you a bill, you want to send your letter or your tender, or you want to send their refusal, and you want to quote UCC 3-603. As a matter of fact, when you send a notice of tender or when you send them your tender, you need to quote it right away. You need to say, hey, under UCC 3-603, if you refuse it, then it is discharged. What are you going to say to that? Oh, well, this law doesn't apply. Well, prove it doesn't apply. Okay. Then we dive into UCC 3-305, which is defenses and claims against recoupment, which gives you valid defenses against enforcement. You have a right to challenge somebody's legal standing to collect on a debt. You have a right to challenge somebody's legal capacity. You have a right to challenge the legality of a transaction under the law. Okay, and if it is illegal, if it is unlawful, if the contract is unenforceable, then this nullifies the obligation of the obligor. Okay, it says it right here. Okay, if you did it under duress, lack of legal capacity, illegality of the transaction, which under the law nullifies the obligation of the obligor. Fraud that induced the obligor to sign the instrument, neither knowledge nor reasonable opportunity to learn its character or essential terms. Discharge of the obligor in insolvency proceedings. So, long story short, if you was persuaded to sign an instrument with no knowledge or opportunity to learn of the character, which is the terms in terms of this obligation or this loan agreement, then technically I didn't really agree. And I can actually defend against that. I can show that you guys gave lack of disclosure, and because of your lack of disclosure, you now lost your ability to enforce this negotiable instrument. Okay, or in other aspects where they try to do things unknowingly or omit information. Why would y'all do that if you guys are moving in honor? And that brings me to my next thing: evidence of dishonor. Okay, so if there's a refusal of lawful tender, then it is dishonor. If you cannot prove that I didn't use lawful tender, right, under the law, then it is a dishonor. A dishonor is actually a violation of my rights. Okay, you must give any and every reason why you dishonored me, and you must prove the dishonor. You must give valid reasons as to why you dishonored. Part of you dishonoring is you ignoring my letters. If you ignore my letters, then that is also considered a refusal of lawful tender. If you send me a bill after I sent you a letter of a conditional acceptance, or I send you specific instructions for you to do or for you to perform, then you have dishonored if you ignore it. Okay, and now you have to show up in court and prove why you didn't dishonor me or how you didn't. And if you can't, you have violated my rights. Okay. Then we dive into UCC 31 USC 5103, which is legal tender, United States coin and currency, including Federal Reserve notes and circulating notes at the Federal Reserve banks and national banks, are legal tender for all debts, public charges, taxes, and dues. Foreign gold and silver coins are not legal tender for debts. Okay. So long story short, somebody look at this and say, well, it says that the dollar is legal tender, but it doesn't say that that's the only legal tender. You dig me? Because when we go back to the definition of tender, it says tender is to unconditionally offer money or performance to meet an obligation. But how about we go to UCC 3-104? Okay, negotiable instrument. Okay, negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order. Okay, long story short, that promissory note that you signed or that loan agreement that they said was an agreement, that was actually a negotiable instrument. That is literally a unconditional promise or order to pay a fixed amount of money, which is something that they then sell as a financial asset. So if you sell this as a financial asset, that is also legal tender. You dig me? So a lot of times people will look at some of these laws, they may not understand or interpret the laws, but again, you have to read it for face value. You have to literally look at it and also read, not only for face value, but read in between the lines. Read what they're not putting up there. If they don't put certain information up there, then that's not all that is to be known. If it doesn't say that this is the only legal tender, then it is not the only, because they'll be very, very specific about certain things. Okay, they can be. This is a whole code, a whole book, and it requires specificity. Okay, then we dive into a 1099-C. Most people don't know what a 1099-C is, but a 1099-C is a form that cancels debt. Okay, any debt that's over $600 can be canceled using a 1099-C. Now, I'm not telling you guys to fill out these 1099-Cs unless you know how to do it as the creditor. But when you get charged, when you get a company charges off your debt, what happens is they fill out this form. Okay. And essentially, they will fill it out as them being a creditor. Okay. They will put your SSN here, your name here. Okay. And then they'll send this into the IRS. This right here discharges an obligation. Discharge is back to what I put here, a lawful fulfillment backed by codes and laws, and can be initiated not only by you, but also by the bank. Okay. Now, if the bank discharges it by filing a 1099-C and they cancel your debt, that means that it was settled. So if it was settled already, what they're supposed to do, and this is what I tell people to ask for when you have a charged off debt on your credit report, is you want to ask them for copy B. Okay, this is important information that should be sent to the debtor. Okay, this also becomes taxable income to the creditor. So understand that when they file your debt and they charge it off, they must send you a copy B of it. If you have a copy B of this, you can take this to the credit bureau and the credit bureau can see that the debt was settled and they must remove it off the credit report. Okay. Then we dive into the Federal Reserve Act Section 16, or we look at the Federal Reserve rules. Institutions are made whole via third parties. So when you understand the whole Federal Reserve system and you understand the nature of obligation, and you understand the things that are highlighted in Section 16, which talks about lawful money, which talks about the aspect of the whole fractional banking system, which talks about how banks literally go to the Federal Reserve and get the money from the Federal Reserve. They don't actually risk their own money. They actually just borrow from the Federal Reserve and show your promissory note as a proof of income. Then now you're in a position of where you can now prove that they never funded the money. You can prove that they not only it's not that you have to prove it to them, but now they have to prove it to you that they didn't fund the money because you know this information. Okay, so when you ask a simple question like how was the loan funded, and it's not that we took it from the Federal Reserve, and it's a lie saying we used our own reserves, that's something that could be brought up in court and is considered a criminal action under 15 USC 1611. Criminal liability for willful and knowing violation. Okay, giving false or inaccurate information or fails to provide information which he is required to disclose under the provisions of this subchapter or any regulation issued hereunder is essentially a willful and knowing violation. Okay, so now that you guys understand that, this is why they don't teach this. Okay, because discharge shifts the power dynamic. Okay, if you start to discharge things, it shifts the power into your hands. Okay, they cannot double dip like they want to. Okay, number two, because discharge honors the contract, it doesn't essentially benefit the collector's preferred process, which is to double dip, which is to not only discharge it, not only get the insurance payout, not only get the money up front, but also come after you with interest and then have a reason to take you to court. You dig me? So again, they're not going to make this easy for you. And this is why you should understand the process, because when you understand the process and you know that they're not going to make it easy for you, they've been double dipping and making triple their money off of your signature and off of your unawareness, then you will know exactly why they decide to reject and decide to say things that don't honor you. There's no point in arguing with them. It's you just state the facts and you state the laws. And if they don't want to go against it, then you take them to court and you have them prove and give a valid reason why they didn't follow the law. Okay? Because knowledge of lawful fulfillment threatens their collection model and not the law itself. It's not about the law that you're messing up. Is about how they collect money. They can't make extra money off of you, so this is why they feel threatened by it, and this is why they always push back against it. Okay, so understand that discharge isn't fraud, it's a performance. You dig me? If you perform on your contract, then you are good. Okay, doesn't mean that you have to pay, you just have to perform. You know what I mean? It is not a loophole. It's the other side of contract law that they do not tell you. So now that we got to this point here, debt discharge isn't about skipping your responsibilities. It's about honoring them with knowledge, not fear. And when you understand discharge as a performance, you stop playing defense and start commanding respect in the system. When you go back and you watch all of my videos that I'm going to give at the end of this video, okay, where it's geared towards where it literally talks about debt discharge. And you really go watch every single video, you will see that I'm breaking down these concepts very in the lamest terms that I can, showing the laws, but also at the same time helping you overcome that mental slavery of debt. A lot of people look at debt and they think that it's something that they should be stressed about, but the reality is like, you know, the worst that can happen is that they'll try to say that you default. But it's a long process that they have to go through before they can come after you for the debt in court. But in the mean in between time, if you know the laws and you are aware of the laws, then you can start to challenge them on certain things. You can start to challenge them and start sending them letters to delay the process and shift the burden of proof onto them. If you understand what burden of proof is, they now have to prove something before they can continue to collect, before they can take any legal action. Okay? You can't go to jail for challenging them on something that they should have already given you and they are required to give you. Okay? So now that we at the end, if you want to learn more about this, definitely tap in with the complete that guide down below. It's only 47 bucks. If you do tap in, you grab the 47 bucks. This is something that you can resell as an affiliate. Okay, you can refer this to your friends, family, and you can also make money at the same time. This right here not only you know, helps you guys, but it also helps support the channel. Okay, when you support the channel, I can keep dropping more videos down here, and it's not that you're just going to be donating to me, okay, but you'll actually be putting towards a good cause, so I can continue to keep dropping these games, so I can continue to keep dropping the videos and things in that nature. But even if you don't do that, just hit the like. Okay, go ahead and subscribe, turn on the post notifications. Okay, also to complete that guide, you're gonna get my discharge strategy guide. You're gonna get a legal tender templates. You're gonna get many different letters and forms that you can learn from. Okay, not just send and hope for the best, but you can learn from. That's my whole goal, is to educate you guys and hope that you guys learn from the information and not just send it off. Okay. Number two, if you want to apply to my one-on-one mentorship, that's down below. This is specifically for people who are ready to invest in themselves, people who want to grow their business, people who want to fix their credit, people who want to get funded. If you're not trying to do that and you want to ask me a million questions on the phone, I would suggest you don't apply. Okay, I'm just keeping it a buck with you. There is going to be an investment attached to whatever it is if you end up talking to me on the phone. But if you don't want to, you want to know something that's up front, $47, go ahead and grab to complete that guide. Learn more about debt discharge on your own time. Okay, you'll have that for a lifetime. And lastly, follow me on Instagram for credit and more updates as it regards to consumer law, as it regards to my YouTube channel, because nobody is talking about this anywhere else. All right. Now, my last question is, have you ever tried to discharge a debt and been told it was illegal? Drop your stories in the comments and let's clear up the truth. Remember to like, subscribe, turn on the post notification, comment the word discharge if you made it all the way to the end, because the law is on your side when you use it in the right way. I love you guys, and I'll see you next time.